Hello everyone, I'm Dr. Varsha Deshpande, and in this video I'm going to talk to you about the theory of separation of powers, which is by far one of the very important constitutional principles. Now, the theory of separation of powers is associated with the name of a French scholar, a French jurist, or a French political thinker named Montesquieu. It's not that people did not talk about this principle prior to Montesquieu. So even before that, the tenets of this theory were something that were being emphasized by a number of people. But this theory is associated with the name of Montesquieu simply because it was Montesquieu who, for the very first time, very scientifically and systematically put forth before us something called as the theory of separation. So, the principles behind this theory were put forth to us in a very categorical form only by Montesquieu for the very first time, and that is the reason why this theory is associated with his name. He authored a book called The Spirit of the Laws, in which he spoke about his idea of separation of powers. Now, what does this theory actually talk about? I think the first thing that one needs to understand about the theory of separation of powers is that this is a theory that is primarily aiming at decentralization of power. It is talking about certain basic things that we need to observe for the reason of decentralizing power. Now, when we say we have created or established the government, what we mean by the government is basically the three organs: the legislature, the executive, and the judiciary. Now, what made us create these three organs of the government? Let us remember, when we created these three distinct and separate organs of the government, we allocated to them certain specific functions that they are supposed to perform. So, probably when a student comes for the first time into a law school, what the student is emphatically taught is that, look, legislature is that branch of the government that makes the law. Executive is that branch of the government that executes or implements the law, and judiciary is the third pillar of the government that interprets the law. So this separation that you see over the three organs, with the three specific functions that these organs are designed to perform under the constitutional scheme, that is primarily the separation that this doctrine talks about. So what we need to understand when we are dealing with the theory of separation of powers is that this theory presents us with a functional classification of governmental power. I repeat, the theory of separation of powers is a theory that is structured upon a functional classification of the three organs of the government. So, you have created the three organs for the purpose of each of these organs discharging certain distinct and specific functions that the Constitution assigns to them. Now, when you say that the legislature makes the law, this is the body that is involved in the task of making law. But making of the law alone does not exhaust the functions that the government is supposed to perform. Having made the law, you now require a mechanism to set that law into motion. You now require a mechanism for the purpose of effective implementation of that law. So, for implementing a law that is made or authored by the legislature, you thereby created the second wing of the government, and you said that this is the executive branch which will be involved in the execution or implementation of the laws. Now, going to the third organ of the government, which is the judiciary, and we say that the judiciary involves itself into the task of interpretation of the law. What do I mean by interpretation? By interpretation, I mean that it is the judicial branch of the state that is constitutionally assigned with the task of expounding the meaning of the words in the statute. So, we need to understand this, that the one who is authoring the law is a separate and distinct branch, and that is the legislature. But if in future sometime we are confronted with a difficulty of what do the words in that law mean, we do not go back to the legislature to ask them, look, what did you mean by these words in the statute? This task of interpretation is performed by the third branch or the third pillar of the government, and that is the judiciary. So, what have we done here? We have classified governmental power on the basis of the functions that the government is expected to discharge. That is why we say the theory of separation of powers is all about what? It's all about a functional classification of the powers of the government. Now, having said this, see, let's understand the basic point, that why do we want the government to, get divided or separated into three organs, and you want each of them to perform their own respective functions? The simplest reason that can be offered about why we wish to do this is because if all the flavors of power come into the same hands, what it will result into is concentration of power. And the moment you concentrate all powers into the same hands, probably you are paving a way for optimum abuse of that power. Recall what Lord Atkin says. He says, power corrupts, absolute power corrupts absolutely. So, imagine if suppose I was the one who would make the law, I was the one who would implement the law, and I am the one who interprets the law. So, all functions, all powers getting concentrated in the same hands. What this results into is, you make me the all-powerful entity within the state, and the moment all power concentrates in my hands, I'm most likely to abuse that power. So, the basic idea behind this doctrine of separation of powers is to decentralize power. You want to depolarize that power so that you ensure that there's no concentration and therefore no abuse of that power. Now, therefore, having said this, that fear of abuse of power, this is the basic fear that conditions the doctrine of separation of powers. Having said this, let's understand that the theory of separation of powers has three important postulates. Now, what are these postulates? Number one, it says, no person shall at the same time be a part of more than one organ of the government. So, at one time, one person can be a part of only one organ of the government. So, if I am a part of the judiciary, I can't at the same time be a part of the legislature or the executive. If I am a part of the legislature, I can't at the same time be a part of either the judiciary or the executive, and so on and so forth. So it says at one time, one person can be a part of only one organ of the government. This is the first postulate of the separation thesis. The second postulate of this theory tells us that no organ of the government shall perform the functions of another. So, we already told ourselves that there is a functional classification. You've classified governmental power on the basis of their functions. So, no organ of the government is allowed to perform the functions of another organ. So, it simply means, for example, that the judiciary can neither legislate nor implement the law. The legislature can neither implement nor interpret the law. So, it's non-performance of the functions of other organs. The third postulate of the separation thesis says that no organ of the government shall interfere in the functioning of another. Now, there's a thin line that separates postulate 2 and postulate 3. In postulate 2, we said no organ can itself perform the functions of another organ. And in the third postulate, we tell ourselves that no organ of the government would interfere in the functioning of another organ. Now let me give an example to substantiate this point that I'm making. Recently, that is in the year 2014, we came up with an amendment to the Constitution and the statute along with it that was enacted, which was called as the NJAC Act. This is the National Judicial Appointment Commission Act. So, judicial appointments in our country were made through a collegium. This is a collegium that decided about who should be appointed as a judge of the Supreme Court. Now, since there was a lot of criticism against this collegium system, saying that, look, it's not transparent and we don't know how these decisions are taken, this had been under the scanner of popular criticism for very long. So in 2014, we made an amendment in the text of the Constitution wherein we said that a judge of the Supreme Court shall be appointed by the President with recommendations or in accordance with the recommendations that would be made by the National Judicial Appointment Commission. So this is a new commission called as, in short, we call it as the NJAC, which was to now take over the task of making recommendations to the President about who should become a judge of the Supreme Court. Now, while this NJAC Act and the constitutional amendment needed for that, while that was still before the Parliament, so Parliament had not actually passed the Act or not actually passed that amendment, it was still being considered by the legislature. At that time, somebody filed a PIL before the Supreme Court saying that, look, this kind of a change, the NJAC Act or this amendment is going to interfere with the independence of the judiciary. So please issue a direction to the legislature stopping it from moving this amendment or making this legislation. Now this PIL, when it came up before the Supreme Court at that stage, the Supreme Court rightly dismissed the PIL saying that, look, this is a very premature case that comes before the court. Now try and understand, what is it that stopped the court from intervening at that stage? Had the court issued a direction to the legislature saying that, look, don't pass this kind of a law because it offends independence of the judiciary, which is already a part of the basic structure, the court would have violated the theory of separation of powers. Because what does this theory tell us? It tells us that, look, no organ of the government shall interfere in the domain of another. Making of a law is the prerogative of the legislature. So if the legislature is in the process of making this law called as the NJAC Act, it is not yet enacted, but it's in the process of doing that, it's no part of the judiciary's business to direct the legislature that, look, don't make this kind of a law. Now what subsequently happened? The legislature successfully enacted the NJAC Act. It brought in the amendment to the Constitution through which it included NJAC within the text of Article 124 of the Constitution. Having done that, could the legislature then go to the judiciary and say that, look, now don't declare this unconstitutional because after so many years with a lot of effort we've enacted this law? The moment the NJAC Act was passed and the constitutional amendment was passed, we had petitions before the Supreme Court of India challenging the validity of that particular piece of law or that amendment. Now here, the legislature can't tell this to the judiciary that please save the validity of this law because with a lot of effort we have after a long time enacted it. Why can't the legislature do it? Because the theory of separation of powers tells the legislature that, look, you cannot intervene in the domain of the judiciary. Pronouncing upon the validity or invalidity of laws is the domain of the judiciary and the legislature cannot intervene there. Let us look at, for example, the Uniform Civil Code. In the text of our Constitution in Article 44, which is a part of the directive principles of state policy, the founding fathers said that, the state has to strive to bring in a uniform civil code because there's a lot of disparity in the personal laws based on religion within this country. So the objective was that we should, bring in something like the Uniform Civil Code, and the founding fathers thought that, okay, maybe at that time we were not matured enough to have something like the Uniform Civil Code, but somewhere down the line, this is what we're going to make a reality in India. It unfortunately has not become a reality till date. But in so many cases that came up before the Supreme Court expressed its deep anxiety that, it's high time we bring in the Uniform Civil Code in this country. It could not direct the legislature that, look, come on, pass the Uniform Civil Code. Why? Because the theory of separation of powers stops the judiciary from doing that. Now, this is the kind of principle that is contained in this doctrine of far-reaching importance. But while I say this, we also need to understand that India is a country that is not a very rigid subscriber to the theory of separation of powers. What do I mean by this statement? We are not rigid subscribers in the sense that, we follow the basic tenets of this doctrine, the basic principle that it is trying to advocate, but we are not very, very hardcore subscribers to the doctrine. Like, for example, if you compare India with America, America is a far more rigid follower of the theory of separation of powers. Now, why are we not very rigid followers? We need to understand the point that there are several examples within the text of our Constitution where the Constitution itself permits a deviation from this theory of separation. So there are a number of examples where the Constitution is legitimizing, the Constitution is allowing a departure from the strict postulates of this theory. Let me give you quick examples to understand this point. Now, the very fact that we are a parliamentary democracy, see, our Constitution established India as a parliamentary democracy. So we are not a presidential democracy like the United States of America is. Now, if you look at the very structuring of a parliamentary democracy, let's understand that in a parliamentary model of government, the upper layer of the executive is a part and parcel of the legislature. So, look at the Prime Minister of India. The Prime Minister is the PM. He is a part of the executive. But this PM is also an MP, Member of Parliament. So, the upper layer of executive in a parliamentary democracy is a part and parcel of the legislature. So this is a deviation from the first postulate of the separation thesis, where we said no person shall at the same time be a part of more than one organ of the government. We mark a departure from this theory to a certain extent the moment we adopt a parliamentary model of democracy. Look at, for example, the President's power to issue an ordinance. When the Parliament is not in session and we are in need of an urgent law, what does the Constitution provide in such a contingency? It says that in such a case, if the Parliament is not in session, the President of India can promulgate an ordinance which will supply the necessary law because the Parliament is not in session and it cannot make that law. So this is an example of President using legislative powers. Our theory of separation says no organ of the government shall perform the functions of another. Here is an example where the Constitution itself allows the President, who is a part of the executive branch, to actually exercise legislative powers. Or for that matter, look at the mercy powers given to the President, the power of the President to pardon. Mercy petitions which are taken to the Supreme Court after a death sentence has been confirmed by the Supreme Court of India. If a mercy petition goes before the President of India, here is an example where the President, who is a part of the executive, is actually exercising a judicial power. So because all these departures from the theory of separation, which I have just pointed out, they are all what I would choose to call permissible departures from the theory of separation of powers. Why are they permissible? They are permissible simply because the Constitution allows this departure. Now, because the supreme law of the land, which is the Constitution of India, that is itself authorizing, itself allowing this departure from the theory of separation, this brings home the point that we are not such rigid subscribers to this doctrine. But having spoken about the permissible deviations from the separation theory, let me also very briefly point out to what I would choose to call as the impermissible deviations from the separation theory. The permissible deviations, as was obviously pointed out, were those which are permitted by the Constitution. But you would today come across some such deviations from the separation theory which are happening at the de facto level, but nonetheless they are not permitted by the Constitution, and therefore I choose to label them as impermissible deviations. Now, what could be quoted as an example of impermissible deviation? Let me talk to you about the important case of Vishakha versus State of Rajasthan. Now, Vishakha versus State of Rajasthan was a case decided by the Supreme Court of India in the year 1997. Now, to bring home the point of what exactly in Vishakha I want to talk to you about, let me quickly give you the factual background of what happened in Vishakha. Now, Vishakha's case was all about a woman named Bhanwari Devi. She was a woman who was employed in the Women and Child Welfare Department of the state of Rajasthan. So, to put it shortly, this woman was a state government employee. Now, the state of Rajasthan had, taken this agenda that, look, we want to create a mass awareness amongst the people in the state of Rajasthan against child marriages. Because Rajasthan, is a state where child marriages are prevalent even today. So the government decided that, we want to create this awareness amongst the people in the state of Rajasthan of how the law frowns at child marriages. So this woman was a very, very activist woman, and she took a great lead in designing strategies for creating this awareness. So what these people did was, they reached out to people in the remotest villages in the state of Rajasthan. They went home to home, actually interacting with the people there and trying to tell them why and how child marriages should be avoided. And their movement got a great amount of success. But while this happened, the whole movement that was going on actually had upset some of the elite members, male members of the state of Rajasthan. So they, were trying to discourage this woman. They tried to warn her a number of times that, look, you better stop doing all this or you're going to face the consequences. But this woman was, as I told you, an activist, and she would not pay heed to all these warnings that were being given to her. Now, one day what happened was, while she was at her work, as I told you, they were going to the remotest of places there in the state of Rajasthan. While one day she was out at her work for this job, she was picked up by a group of men, taken to a secluded place, and was brutally gang raped. Now, this matter actually angered everybody, but more particularly the feminist organizations in the country. So the case went into the criminal court. There was an embarrassing and tedious trial that happened. But at the end of it, the criminal court could not really convict anyone for want of appropriate and enough evidence. Now, this actually angered, as I said, a number of feminist organizations. Now, one such NGO named Vishakha went to the Supreme Court of India with a public interest litigation under Article 32 of the Constitution. And what did this NGO called Vishakha point out to the court? Let me clarify this, that this PIL before the Supreme Court was unconnected to the criminal proceedings that happened in the court below. So it was not in the nature of an appeal. It obviously was a public interest litigation that was brought before the Supreme Court. Now, what did this NGO called Vishakha point out to the Supreme Court? It drew the attention of the Supreme Court to the fact. It said that, look, what is this pitiable situation in which the women of our country are living even today? That even till date, we do not have any comprehensive law in our country that addresses the issue of protection of women against sexual harassment at workplaces. So they said even today, and even today means I'm talking about 1997, because Vishakha's case was decided in the year 1997. So it pointed out to the court that, look, what is this deplorable situation in which women in our country are living even today? That we have not been able to enact a single law that is addressing the issue of sexual harassment of women at workplaces. Now look at it in the context of the functional classification. That, if we do not have a law in our country on this point, actually lawmaking is the domain of the legislature. And the theory of separation of powers told us that no organ of the government should perform the functions of another. So, in this case, if probably the court would have said that, look, we understand the point you're making, but we're very sorry we can't do anything about it because lawmaking is the function of the legislature. Had the court done this in Vishakha case, strictly constitutionally speaking, probably the court would not have been incorrect. But what does the court choose to do? Justice Verma, heading the bench of the Supreme Court at that time, this is an outraged court again. So it says that we are, our conscience is shocked by all that which is brought before this court. So it says that, look, if there is no law on this point, forget it. We will lay down the guidelines. And that is how in Vishakha's case in 1997, for the very first time, you saw the Supreme Court of India laying down specific guidelines against sexual harassment of women at workplace. And if you look into the original judgment of the court in Vishakha, you will see that the court has laid down guidelines like a law that is enacted by the court. So, law that is enacted by the legislature. When the legislature makes the law, it prescribes section 1, section 2, section 3, section 4. You look at the guidelines of the court in Vishakha's case, 1, 2, 3, 4, it gives you a list of guidelines. And the court doesn't stop at that, mind you. It says, we are laying down these guidelines, and until the Parliament enacts a law on this subject, our guidelines will operate as the binding law of the land. So what does the judiciary do in Vishakha? In Vishakha, you see the judiciary actually legislating like the legislature, which, mind you, on the strict principles of theory of separation of powers, the judiciary is not allowed to do. Because your theory tells you no organ of the government shall perform the functions of another. Now, therefore, because what the judiciary did in Vishakha is something that the Constitution does not permit the judiciary to do, this would probably fall under the umbrella of what I choose to call as impermissible deviations from the separation theory. Now, there are two ways in which one can understand or analyze Vishakha. Probably from the restricted point of view of the fact situation that backs, bringing of that petition before the court. In the context of that factual situation, if you try to understand the Vishakha judgment, probably this is one of the wonderful things that the court did. So, this became a matter of great discussion after the Vishakha case was decided. We applauded Justice Verma's effort and the judicial activism that was shown by the judiciary in saying that, look, we are not going to sit down with folded hands if there's no law made by the legislature. Legislature hasn't legislated upon it, forget it. We are going to supply the law to fill up that legislative vacuum. So from that point of view, probably what the court did in Vishakha was fantastic. But from another point of view, if you look from the strict spectacle of constitutional law, we need to understand that the judiciary ended up doing something which the Constitution does not permit it to do. And we saw the repercussions of this because, the post-Vishakha case, if you try to analyze, on and off you see the court doing that, whether the factual situation in the case demands this kind of an extraordinary action or not. So in so many cases post-Vishakha, you heard the court saying that, look, there's no law on the point, forget it, we are going to lay down the guidelines. So by doing that, what has happened is we have almost routinized what was thought to be extraordinary in Vishakha. We have normalized the extraordinary because in the post-Vishakha period, you see the court so often taking recourse to this strategy of laying down guidelines to fill a legislative vacuum. But there, we have completely deviated from what the theory of separation of powers tells us. So, you see a number of cases where the judiciary is actually legislating like the legislature. You see the judiciary prescribing a completely new law like the legislature should be doing. In fact, to a large extent, even the evolution or the writing down of the theory of basic structure by the judiciary is also looked upon as an example of judicial legislation, because prescribing new law is not the domain of the judiciary at all, and yet you see the judiciary engaging in this, and that's the reason why we look at this as an example of impermissible deviation. So the point that I'm trying to make is this kind of intermixing of the functional space between the legislature and the judiciary, that's precisely the dangerous precedent that Vishakha's case holds in its womb. That thereafter, you've routinized this tendency of the judiciary laying down guidelines so much that probably today you are not even questioning the correctness of this strategy. So therefore, these kind of examples fall within the domain of impermissible deviations because they are not permitted by the theory of separation of powers. Towards the end of this video, let me make one definite point. That today, we are living in an age of intensive form of government. So there are a number of functions that the government of the day is expected to discharge. Now, in this model of an intensive form of government and the welfare state philosophy that we have adopted, a complete watertight separation of powers is something that's probably not possible at all. So, we can't have a watertight compartmentalization of the three organs of the government at all. Instead, we could probably think about advocating something called as the theory of association of powers. So, where we do not really talk about separating the three organs into separate watertight compartments, but we allot to each one of them their legitimate space and then talk about association of powers between these three organs. That's an important point that I had wanted to make at the end of this video that talks of separation of powers. I sincerely believe this video on the theory of separation of powers would be useful and helpful to you. Thank you very much for watching this, and the next video that I would come up with before all of you, it would be on the basic concept of fundamental rights in the text of our Constitution. Thank you very much.
For more such informative topics on constitutional law, please like this video and subscribe our channel.